screen, just so that we can establish how to proceed, because even though Chapter 7 of the textbook has the heading of the institutions supporting constitutional democracy, there really are only two institutions of actual relevance to constitutional, and that is the Independent Electoral Commission and the Public Protector. And that's why they're underlined in the notes that I sent out earlier today. So Mr. Mudau, in fact, he just wrote an article that was published yesterday about the Independent Electoral Commission. So he's going to be doing the section on the Independent Electoral Commission, while I do the section on the Public Protector. And neither of the two sections are very long, so this shouldn't be a long lecture at all. So I'm now going to see from Mr. Mudau how he feels. Would you like to discuss the Independent Electoral Commission first? I think it is also interesting in the Constitutional Court's hearings the whole day today about whether or not the court can fear the determination of the election dates and whether it is the Constitutional Court that is the correct body. So, Mr. Mudau, how would you like to start, and then I follow from you?
It's fine, you can start, Prof.
Okay, that's perfect too, because I'm going to be go to our screen. And so you do know, obviously, everyone, that I sent these notes out earlier today. And it is only 5 pages, so you don't need to feel too intimidated. And I've said here clearly that we've underlined the Public Protector and the Independent Electoral Commission, the only two that you need to know for constitutional law. What we are particularly though is what two institutions do and how they support our constitutional democracy. And so in simplistic form, in the little table, I've said here that the main tasks of these two institutions are to monitor our government so that we can ensure accountability, and in addition is to transform South Africa so that social justice can prevail. So we hope to convey that it is these two institutions that are actually able to give effect to these objectives. So we must view the Public Protector and the Independent Electoral Commission as monitoring tools to make sure that the rule of law is complied with. And what I mean by that is that constitutional obligations are given effect to. And so we place so much emphasis on these two institutions because we know from lecture 1 that elections in South Africa were never as envisaged in the current constitution in the South Africa's colonial and apartheid past, because the elections were not multi-party in the true sense, because there were only ever 2 white political parties that could contest, and we know that they were not multiracial elections. And in fact, the entire system was flawed. So there never was an institution whose sole purpose was to make sure that every 5 years we have free, fair, impartial, multi-party credible elections that represent the views of the entire society. And likewise, if we take advantage of that opportunity of participating in the elections, it means that democracy will actually be given meaningful effect, because then the views of every single person can be given effect to. And if the people are empowered to vote for the right political party that they believe will stand up for their opinions and their interests and what is necessary to make society more cohesive and developed, then we will ensure that that history of oppression, segregation, and discrimination that But at the same time, we also know that our politicians, who we vote for in good faith, are only human beings and they are fallible. And that's why we have the public protector, because the public protector is there to ensure accountability and that the Constitution is honestly taken into account when decisions are made by anyone exercising a public power. And if the public protector then finds that there is any conduct which is either corrupt or even simply where the process is taking too long and there's no explanation for that, or where there is apparent maladministration, so government is spending money on the wrong things instead of on service delivery, for example, it is the public protector who has the right and the power in terms of the Constitution as read with the Public Protector Act to actually investigate these allegations, and not just investigate, but to make findings based on the investigation. And most importantly, and it's what I'm going to be emphasizing primarily, is that the decisions reached by the public are now unambiguously binding and enforceable. So that's how we know that the public protector is actually a legitimate institution in terms of the Constitution, and that the money spent on appointing a public protector and making sure that the office of the public protector functions properly is not wasted, because there was so much controversy and confusion about whether the decisions of the public protector were binding and implementable. And we now know definitively, thanks to the 2016 case of the economic freedom fighters versus the Speaker of the National Assembly, where it is now proclaimed that the public protector's decisions must be implemented unless they are set aside by a court of law. And independence, then, I've emphasized it here, is the essence of how we are to understand the Electoral Commission and the public protector. Because what we mean by independent is that these institutions, even though they're not judicial, so they're non-judicial institutions, but they also have original constitutional powers, but they do not form part of either the executive, the legislature, or the judiciary. That's why on page 6 of tutorial letter 102, in that diagram, I show you that the Independent Electoral Commission and the Public Protector are completely separate from the legislature, executive, and the judiciary, but there is a line, a dotted line between them and the judiciary, and you could even convey that to the dotted line, also including to the executive and the legislature, because they have a role in being able to determine when the rather the executive or the legislature has not acted properly, and therefore when the judiciary should step in and be able to declare that someone has been found guilty of some form of misconduct or mismanagement, if that is indeed what the finding of the public protector has been. I see that my page seems to, okay, I hope it's still being shared. So I'm going to focus now, as I say, on the public protector. And what is the part that I actually started with in the lecture notes, and which I have to a large extent delayed stage, is because this particular point that is being made here in the Minister of Home Affairs versus the Act is the exact argument that I was looking for you to make in the answer to question 1.1 of assignment 2. And what that is that just like our legislature and just like our executive must at all times act the powers conferred on the public protector are that the public protector any and all allegations of abuse of power, corruption, and any conduct that is prejudicial to the community or the society at large. And so he or she, and usually a she at this stage, that their sole purpose is to rationally investigate the facts before them as contrasted against the power conferred upon him or her. So that rational connection test, or the rationality between the power of the public protector to be able to, that someone who holds any position of power or exercises a public power is in fact guilty of gross misconduct, for example, because powers her to do that. So we are expecting then that at all times the public protector acts rationally, and we saw that more clearly then in the more recent case of the Democratic Alliance and versus the public.
Hi, Prof. I'm sorry, we can't hear you. Keep breaking up. And I know that you're in Word, so you can't see the comments, but you keep breaking up.
Okay. Yes. Okay. I'm going to, well, hopefully I'm not breaking up too much, but Everything I'm saying is based precisely on these lecture notes. Answer I was looking for your assignment. So you should already be familiar with this in any event. But all we need to establish when valid and defined is you engage in what is known as the rationality test. And there, what the court does is the court first looks at
We can't hear you, Prof. The sound hit away.
It's not working.
Yes, unfortunately, we cannot hear you, lecturer.
That's quite strange. Can you still not hear me?
We can hear you now, Prof.
Can you hear?
We can hear you, but you're not clear. It's been breaking from the beginning. So, yeah, maybe you can change your Wi-Fi or something.
Look, I can't really, but it should, let me move slightly. Maybe it's where I'm positioned.
Yeah, now can
okay.
hear you loud and clear.
Yes, hopefully
it
this
sounds
is now
much
a little
better,
bit
Prof.
better. Okay, good. So this part that I'm discussing with you now, as I've said, is actually precisely what your assignment question was on. But now I'm relating it to the public protector, whereas in your assignment it was related to the provisions of the coronavirus regulations and whether they were rational. And by now, therefore, you should know that the rationality test simply asks, what is the power conferred on the public protector? In other words, is she allowed to investigate corruption, abuse of power, any kind of prejudice caused to a person? Yes, she is. Has she then investigated all the material facts and reached a conclusion where you can see that there is a rational link between what the powers are that she has and the decision she's reached, where she has been able to affirmatively proclaim that there is corruption or that some high-ranking official was unduly enriched at taxpayers' expense? And the response should hopefully be, yes, the decision is rational, and therefore it's rational and must immediately be complied with. But if you look at the decision of the public protector, and in your opinion, there is no rational link between the power conferred on her and the decision she has reached, then it is perfectly possible to go to court and ask the court to set that decision aside on account of it being arbitrary and inconsistent with the power vested in her. And that is what we saw happen.
Prof, are you still here? Sound hit away again.
We've lost you, Prof.
Okay, I'm still here. Yes, my internet is not great, but I think we'll be fine. It is possible to have the decisions of the public protector set aside if they are irrational. But in all other respects, at a minimum, what we're expecting is that the public protector exercises her powers in good faith and strictly interprets the law that governs her conduct, so the Constitution and the Public Protector Act, and juxtaposes that with the facts presented to her. So our main point of departure is that up until 2016, we were all confused about exactly what
Professor, you went off again.
Professor, are you still here?
Okay. Be very quick. Every single thing I'm saying is on these lecture notes, and I know some students rely on the recording, but since it's not going along very well, I'm just going to be try and be very brief and just confirm what you already know. EFF versus the Speaker of the National Assembly case, where Thuli Madonsela had investigated the Nkandla matter. So if you know the Nkandla matter and you know that the public protector investigated whether the upgrades to former President Jacob Zuma's homestead at Nkandla were security related, but the public protector found that they were not all security related, and he should therefore pay back. It was that case where the Constitutional Court said, we have now reached the point where there is no longer any confusion. The public protector's decisions are binding and must be implemented as soon as possible. And so I'm not going to read these long quotes, but really the court was, the public protector plays this important role because the office of the public protector is approachable for free. So no one has to pay for that of investigate. For example, funding, or you're applying for a disability grant and you never receive a response. Your councillor in your municipal agency, you can't quite understand how that came. It might prove that there's corruption happening. You can go to the public protector free of charge. A scenario of the David versus Goliath, because then who is in the vulnerable position because you're all alone and you don't have the money to go to court, you the public protector act on your behalf, make decisions that will assist you actually realize your right. Social justice in particular prevails. So that's why we say that the institution is pivotal to the facilitation of good governance. And more important, the public protector has powers that leave no power above scrutiny. So not even the president beyond reproach. And it is just too bad if the investigation does lead to coincidental embarrassment, which is what happened with former President Jacob Zuma. He was embarrassed by the fact that there were allegations benefit upgrades, and the protector can censure or sanction, or for want of a better expression, make a pronouncement that the person has engaged in corrupt or abuse of power because of who they are. And so the court is clear that any remedial action imposed by the public protector is binding, or else what would be the point of it? And therefore, and is only not binding if someone actually goes to court and says, I disagree with the findings, and the court then agrees that the finding is irrational. To make it clear that serve at the public protector, and where money is invested in the office of the public protector, yet these decisions of the public protector are meaningless. So the court emphasized again in this seminal 2016 case of EFF versus the Speaker of the National Assembly that the public protector strengthens our democracy. She helps to uproot prejudice, impropriety, abuse of power, and corruption throughout the government, national sphere, in the provincial sphere, even in the local sphere. That's how far-reaching. So then, that the public protector needs to investigate and then reach a that is suitable, fitting, proper, effective. In other words, will her remedy be able to rectify the situation and the situation be in the Nkandla matter, that the court was so adamant that the only way to rectify the situation is to do what Thuli Madonsela had advised, which is that the president pay back the amount by which he enriched at taxpayers' expense. Like we saw, didn't like it, doesn't for it. He can only try to reject the decision by going to court and having it formally set aside. But in actual fact, it's not up to anyone to simply ignore the decisions of the public protector. Otherwise, find or locate the provisions by which the public protector are is Constitution, which is then read Act, and it's said already, the public protector is there to investigate all allegations of impropriety, prejudice, corruption, and to report and is to actually come up with a finding which says the person must pay back the money, or the person in the Department of Home Affairs who refused to register the birth of your baby because you didn't pay them 500 Rand, that person must be disciplined by the Department of Home Affairs. And so that is accountability in its true form. Because if no one had approached the public protector to complain about any conduct, no one would know it was happening, and you as the victim would be disempowered. But we know now that we all have the right to approach the public protector to seek justice and to bring back the equilibrium, so not allow certain people to be benefited by corruption. What we need to emphasize is that the public protector is what we deem to be an active participant, meaning the public doesn't sit back and wait want you to get, please go ahead and do so. In fact, the public protector go to or individual autonomous power to start investigating matters as he or she becomes aware that there is alleged impropriety. So we know then that the public protector allows the public protector, the public protector legislation, it empowers the public protector to take initiative.
I'm not sure.
And to act.
Hello?
Yes?
You are breaking up. We can't hear anything. It's just bits and pieces, and the slides are not visible as well. I'm so sorry, but that's how I'm getting. I'm not sure if it's a network, but it's like just bits and pieces, and the slides are also not clear. So it's difficult to follow. And
okay. Then let us try this. See if Mr. Mudau is ready to lecture, and then we can try again after that. Mr. Mudau, how does that sound to you?
Prof, I was just editing my PowerPoint.
Okay. Now I know. Let me try a different position now, again, and see if this makes any difference. Let me try this.
I think it's not just your side. I think it's a national problem, the network issue. It's been happening throughout the country. So it's not just your side, but we appreciate all that you're doing. Thank you so much.
Let me just say, though, if you can even hear me, that
you're gone. We've lost you. We can't hear anything now.
okay. So what I was saying, can you hear me now?
Yes, sir. Yes, ma'am.
Okay.
Yes.
All I was saying is these 5 pages that I sent out earlier today is everything you need to know about the public protector. So
Prof, we lost you.
Gone again.
So try to read these notes for yourself. and understand it without
Yeah, I know. Unfortunately, even the recording is going to be bad. We've completely lost you now, Prof.
Does that make any sense?
Prof,
We did.
can you
No,
please
no.
repeat what you said because
We didn't hear a thing.
Anything, Prof.
may you please repeat your previous what you stated previously? I didn't get that.
Okay, I was just that what I'm saying to you is in these very short 5 pages that I uploaded on my UNISA. This is everything you need to know about the public protector. So you can read them yourselves instead of relying on a lecture.
I'm ready now. If the experience is continuing, I guess I can try to present my part of the lecture.
Well, let's try Mr. Modau and see if sorry, what were you saying, Mr. Modau? I actually didn't hear you properly.
I was saying, if the inconvenience on your part is continuing, I could myself come in the lecture.
Well, let's see if your part works then. I think that's an excellent idea. Let you start. And then we see how things develop.
Can we share both our screens at the same time?
I did remove mine. I'm sure yours. Mr. Modau, have you been able to share your screen?
Oh, I'm to share it now. It's just that it keeps on showing that it's uploading.
Okay.
But I've not yet been
No,
given
there definitely must be a network issue affecting all of us.
Sorry, Prof. I'm not sure if you are able to hear me. The network problem seems to be a national thing that's been going on over the past few weeks. I'm just a bit worried about the exams, though. If we are online and we experience these kind of network problems and we're not able to submit our answer sheets on time, if you could provide us with a way forward in advance so we wouldn't panic at the last minute. I'm not sure if I'm audible. Thank you.
You are perfectly audible. I'm going to try to respond and hopefully you can hear me. So, as you know, the exam is apparently on the 6th of September, which is very close. And I must say I was as shocked and horrified as ever to learn that on Saturday morning because I had been told that the exam was on the 1st of December. So all I'm saying is this: you have 4 full hours to answer the questions. And it's 20 questions. None of them are very, particularly difficult. Simply going to be a case of writing true or false and giving your reason. And then there's a 25-mark essay. So 4 hours should be more than enough time to submit that. Remember, you also get a full additional hour to upload your answers. And if during the exam there is trouble and you can't submit, and there are a lot of you complaining that you can't submit, at that time right then and there. So I don't think you'll have any problems, because you do have a lot of time and it's not a lot of writing you really need to do for this exam. But I'll promise you we will be able to attend to it if you cannot submit. Did you hear that?
Thank you so much. You were so clear. I did hear that, and thank you so much. You say it's going to be a 25 MCQs, multiple choice questions. Oh,
25,
true and false.
Yes. Yeah.
Okay. And even for the true answers, we need to provide reasoning.
Yeah. And that's where you get the other 2 marks from, which I noticed many students in the past didn't justify their answers, so they threw away 50 marks for nothing. So that's why you need to justify, even if the statement is true, you need to be able to say, yes, it's true, because section 172 is the applicable provision. Is president
Thank you so much, ma'am. Really appreciate
South Africa. So 4 hours should be more than enough, and you have an extra hour. So I'm seeing hands up. I don't.
Prof.
Yes, I'm listening.
Okay, I just want clarity. Now, you said we will be given an extra hour. Then does that imply that we'll be given 4 hours for exam? Thank you.
Yes, it's 4 hours for the what they call grace period. You're supposed to use that last hour still to be answering, but to submit.
Okay, we got that email where you explained that. Thank you. I just want to find out, you mentioned the exam is on the 6th of September. I got that email. However, the timetable is still not uploaded on my UNISA. Like, we don't know when they're going to upload and how we're going to get access to write that exam, because they didn't clarify when they're going to upload that on my UNISA exam timetable. I don't know if it's just me, but...
No, it's you, not the only one. I had experience with another student this morning who had the same query and was very concerned because it doesn't show yet on the timetable. I don't know when the final timetable will come out, and I am hoping that the CSL exam is not going to be on the 6th of September when it does come out. Only because I don't think we will have finished marking all the assignments by then, because we didn't expect it to be so soon. Oh, is the timetable out? Okay, well, I haven't seen the final timetable.
Neither has many of us, Prof.
Sorry.
And so sorry for interrupting, but is there a possibility, Prof, just like you're saying that you haven't drafted yet the final paper and you haven't gotten any feedback for assignment 2, but is there a possibility at this point that the exam can be moved?
I'm not sure. I know that some students have been writing to the SRC and to other university structures, but I have no idea what the results of that are.
And also, Prof, the problem becomes some of us have to book study leave off. So
I know.
Yes, so if we don't have an official timetable, because now some of the modules are written module arrangement, or whatever the case is. So now it's impossible for I personally, for example, need to book study leave 2 weeks in advance. I can't do that if there's no final timetable that has been released to us and says, yes, on this particular date, I will be off due to the exam.
Yes,
So
I know that.
When do we expect to receive something formal from the university so we can book our 15 days of annual study leave, etc.?
Well, and I don't know, and I don't know how you're going. You see, that's my is for students to be there on the 6th of September till 29th of November of continuous stress, very helpful to your health. And I'm saying that I don't know when the final timetable will be released. I really have no idea.
Ma'am, can
Hello. Sorry, Prof. I just want to check maybe as the lecturer, what kind of maybe the level of maybe influence, if you can state your reasoning for the date of maybe 1st of December. Will the institution maybe more listen to you given the whatever the difficulties that we are facing? Hello?
I'm sorry, my internet stopped working. You're going to have to repeat your whole question, please. I'm sorry.
So, yes, Prof. I was just saying that since maybe initially you were informed that our date is going to be the 1st of December, and now we are shocked to find out it was on the 6th of September. From your position, are you able maybe to have an influence in terms of the institution moving the date as per what you got, and also given that you are still marking some of the assignment, and it won't be, some student maybe might write exams without having received their marks for the assignment.
No, I know, and that's why I've tried with the College of Law tuition department, and they told me there's no chance of a change. But I have been in contact with students who've said that they've written to the SRC and to, I think, the Dean of Students. So I don't know how successful that will be. I don't know who to contact about the timetable. Really, we as lecturers have no involvement in the timetable. We weren't even consulted. We were just told 1st of December, then a week later I was told 6th of September. So I don't know who to contact. You can try to write to exams. I don't know if you'll get a response, because even I don't get a response from exams.
Prof.
Yes?
Prof. I hope what you explained means that the date of the 6th still stands for exam.
Repeat that, please.
Or I hope what you try to what you explain now simply implies that the date of the 6th still stands for examination on the 6th of September.
Yeah, I think we need to move on from the point that the exam will be on the 6th of September, because I don't know what the chances of a change to the date are.
Hello, Prof.
Yes.
But then, Prof.
Yes.
But then, how fair is that? Because by then we will not have the feedback for the assignment. We will not know the year mark, but yet we are expected to write the exam.
I don't know. I have just written an email about this to my line manager because I'm so concerned. I haven't had a response.
Really, it's not fair.
I just did say to my line manager that we've got thousands of assignments not yet marked and we won't be finished by the exam. But I don't know if that will make any difference to the outcome. Yes.
Sorry to disturb you, ma'am. I think every single one of us that's attending the lecture has a problem with the timetable.
Yes.
If we continue discussing this, we're going to miss the point of what we are supposed to be. We need to concentrate on the lecture. If they could probably post their questions after the lecture, but I think we need to focus on the lecture right now.
No,
Thank
that's
you
fine,
so much, ma'am.
Yes. No, I agree. I'm happy with that as well because we are just talking in circles since I don't have an answer. And so, Mr. Mudau, please do feel free to continue.
Can you see my screen?
Yes.
Yes, we can.
Right, thanks a lot.
Happening. Please, Mr. Madam.
So the lecture which I'll be presenting today will focus on the Independent Electoral Commission. So it is one of the key Chapter 9 institutions that are central to South Africa's constitutional democracy.
Mr. Mudau.
Yeah.
Mr. Mudau, can you please raise your voice?
Yes, I have raised it. Am I still not audible?
You
Not
are.
enough.
I can hear you.
You are. We hear you now, Mr. Mudau.
I think some people need to raise their volumes on their side. Some of us are hearing you perfectly well.
Yeah, I agree.
We now hear you, Mr. Mudau. You can continue.
All right, thanks. So as I was saying that I'll be presenting, looking at the Independent Electoral Commission, which is one of the key Chapter 9 institutions together with the Public Protector, the one which Prof. Leastone was presenting about. Hopefully she'll be able to continue with the lecture after my presentation. So the Electoral Commission is part of the state institutions that are there to support constitutional democracy. So what you need to know is in the modern constitutional formations, what is happening is these institutions, they form part of the key elements in modern constitutionalism. It is the last one in most constitutions that people actually concentrate on. You can see that I have listed some of those elements, the recognition and protection of fundamental rights and freedoms, the separation of powers, an independent judiciary, the review of the constitutionality of laws, the control of the amendment of the Constitution, and lastly, state institutions that support constitutional democracy. So the IEC forms part of these institutions, meaning its significance in terms of promoting, strengthening, sustaining constitutional democracy is actually forming part of the broader goal of achieving constitutionalism and a very vibrant constitutional democracy. The present
You have disappeared,
We
Mr.
can't hear
Modau. You have
you.
disappeared. Mr. Modau, you have disappeared.
I'm close to my mic. Perhaps the connection, the nation-wide connection problem is the one which is affecting my presentation as well.
You're back now,
So,
but you did disappear. So you're back now.
oh, okay. All right. Thanks. The presence of such institutions being mentioned or being given constitutional protection and powers in order to safeguard constitutional democracy does not automatically guarantee that there is constitutionalism or the existence of a vibrant constitutional democracy. I can give example looking at Uganda and Zimbabwe, where electoral commissions as well as other state institutions that are supposed to support or promote constitutional democracy, they are just there to rubber stamp the decisions of those who exercise or exert political will. We know that over the years, the electoral commissions especially in Zimbabwe, they are functioning in a very political partisan manner. They are actually favoring the ruling party, and we've seen what happens in Uganda, where during the counting of ballot papers, they can be internet shut down, electricity shut down, and after the restoration of the electricity, you may find that the ruling party is the one which is actually leading the opposition parties, and it is impossible for state institutions that are supposed to support constitutional democracy to actually function without their constitutional independence being respected, because they need to function in a very fair and impartial manner. However, it is impossible for them to execute their constitutional mandate with distinctions if the political will or influence actually interferes with their work. So what you need to know is the presence of such institutions in the Constitution, it actually helps in order to promote constitutional democracy. And there is also the prospect of achieving constitutionalism. However, in the absence of such provisions that establishes state institutions, the chances of achieving constitutionalism and constitutional democracy becomes very bleak. And finally, I can state that it is the cumulative effect of these core elements that enhance the chances for constitutionalism and a vibrant constitutional democracy. The Electoral Commission, often abbreviated as the IEC, is established in terms of Section 181, Subsection 1F of the Constitution. And it is conferred with 3 constitutional mandates as stipulated by Section 90. So these 3 primary mandates is to manage the elections of national, provincial, and municipal legislative bodies in accordance with national legislation, to ensure that those elections are free and fair, and again to declare the results of those elections within a period that must be prescribed by national legislation, and that is as short as reasonably possible. And the Electoral Commissions Act on Section 4, Subsection 1, Paragraph N, it declares that the Electoral Commission is supposed to declare election results in a period within 7 days after elections. However, we've seen that in practice, the IEC in South Africa mostly has been declaring election results within a period of 3 years. And what I can confirm with you is if the people on the ground, voters, political parties, and the election stakeholders are used to the IEC declaring elections within 3 days after elections, although the Electoral Commission's Act says within 7 days. People might complain that there is a high chance of the elections being rigged, because in practice it's often 3 days, but why should you expand beyond 3 days, even though the Act says within 7 days, but people are used that to witness the election results, whether it says the national and provincial elections that are held concurrently, or the local government elections that are held separately from the other national and provincial elections. Were used to witness the IEC declaring election results within 3 days. So the objects of the IEC are stipulated in Section 4 of the Electoral Commissions Act. These are to strengthen constitutional democracy and to promote democratic electoral processes. So what you need to know much about the democratic electoral processes is that one of them is the civic and voter education, where the IEC, together with the relevant stakeholders, mostly civil society organizations, they conduct voter education programs that are meant to encourage voters to participate in electoral processes, in particular elections. So the powers of the IEC are listed in Section 4 of the Electoral Commissions Act. This includes managing any election, ensuring that any election is free and fair, promoting conditions that are conducive to free and fair elections. You know that in other African countries, it is impossible for the IEC to promote conditions that are conducive to free and fair elections, because you may find that the army or state apparatus that forms part of the security and the defense organs of state, they actually form part of the governing party's tools that are used to violate democratic rights. We've seen in Uganda where around election times, during post-elections, during elections and even post-elections, the security forces are used to violate people's rights. They are beating, intimidating opposition members and their leaders so that they wouldn't be able to campaign well and present their manifesto to potential voters who could be convinced to vote for the opposition parties. So that's a rife or general challenge that is being witnessed mostly in Africa. However, in the context of South Africa, we all know that the IEC has been able to create conditions that are conducive to free and fair elections. Then the IEC again is supposed to promote the knowledge of sound and democratic electoral processes, then promote voter education. So voter education is more about ensuring that the people who are going to vote, they are aware of the voting processes, what needs to be done when they reach the voting station, producing their ID, and they must also verify from the voters' roll that they are actually registered and they are in the correct voting station. And during a certain election, whether it's national and provincial elections or local government elections, how many ballot papers are voters supposed to receive and how to vote, so that they wouldn't have what is called spoiled votes. You need to ensure that when voting, you vote correctly so that their vote could be counted, and how to cast your vote in the ballot box. So these are part of the key duties that the IEC is supposed to ensure that it promotes within the society at large. And the last duty or function that I have listed is to demarcate wards in the local sphere of government, or to cause them to be demarcated. So you know that the wards are for ward councillor candidates who wants to compete into local government elections to be elected as ward councillors that represent their constituencies in the municipal council. In most cases, half of the municipal council members are ward councillors, while the other half is the proportional representative councillors that are elected through political parties. So the wards which a candidate, whether under competing under the auspices of a political party or as an independent candidate, you are competing within a particular ward. Upon being elected, then that means you will be representing that constituency in the municipal council. So one of the key or fundamental features of South Africa's Electoral Commission is its well-known independence that is conferred by the Constitution. And again, in practice, we see that the executive or organs of state, they actually respect the independence of the Electoral Commission. And in Section 181, subsection 2 of the Constitution, there is a general guarantee of the independence of state institutions that are supporting constitutional democracy. These independence is actually applicable to all of them. Then, in terms of subsection 3 of the very same provision, you find that the Constitution requires that organs of state are supposed to assist and protect the independence of these state institutions, including the Electoral Commission. And again, interference with the work of the Electoral Commission is prohibited in terms of subsection 4. In the case of Independent Electoral Commission versus Langeberg Municipality, which was delivered in 2001, the court held that the IEC does not form part of the government, but forms part of the state. As we proceed with the lecture, there is somewhere where I'll be trying to to provide a distinction between a government and a state. And the independence of the Electoral Commission is also affirmed by Section 3, subsection 1 of the Electoral Commissions Act, which is almost a copycat of what is provided for in terms of Section 181, subsection 2 of the Constitution. And here, I will therefore emphasize that one needs to take a strong attention to the founding values of South Africa's Constitution as stipulated in Section 1 of the Constitution. And this section, it states that the Republic of South Africa is one sovereign democratic state that is founded on the following values. It lists a number of them. Then the ones which are listed under subsection D are central to a constitutional democracy and the democratic electoral processes. These include the universal adult suffrage, where the IEC, in its execution of its constitutional mandate, needs to ensure that all people who will be participating in the electoral processes are actually 18 years or above. And there has to be a national common voters roll where all people who registered to vote could be able to be seen, to be identified in terms of their full names and the municipalities and the voting district which they belong to, so that it could be easy for a voter to locate their voting district and to participate in the democratic electoral processes. Then the other value is to ensure that there are regular elections. It is in relation to periodic elections that are in South Africa. They are being held within 5 years. Holding regular elections, it helps in terms of promoting a stiff competition between competing political parties or candidates who will be offering to voters different policies and manifestos on how they will change their lives. And the local sphere of government is the one which is key in terms of promoting democracy, because it is the sphere of government that is closest to the people. And decentralizing powers to local governments is to ensure that democracy becomes well ingrained. That's when one could be able to vote for a candidate who actually takes decisions that directly and indirectly affects their day-to-day lives, especially when you look at the ward councillors, which receives their governing mandates from the constituencies or wards which they've been elected to represent in the municipal council. Then the other, or the last value, it is the principle of a multi-party system of democratic governance to ensure accountability and also to ensure responsiveness and openness. Having a multi-party system of democratic governance forms part and parcel of ensuring that the competition among political parties, it actually entices the governing leader or the governing party to do what's best for the voters, because failure to satisfy voters while serving in government can result in one being voted out. So having a multi-party system of democratic governance is actually central in terms of achieving a very vibrant constitutional democracy. We've seen in other countries in Africa where there is a multi-party system of a government that is allowed. However, it's not actually democratic because other opposition parties are being stifled, especially during elections. They do not have the same campaign rights or powers as opposed to the governing party or the incumbent president who is in power. We've seen in Zambia in the recent elections where the incumbent President Edgar Lungu tried to ensure that his opposition, the opposition leader Hakainde Hichilema, does not actually have the same voice in terms of engaging with the electorates. Funny enough, the opposition leader Hakainde Hichilema, who has already competed 5 times in the elections, he has went to win the elections in a very decisive manner with a huge margin between him and the incumbent president. And very soon the opposition leader Hakainde Hichilema will be inaugurated as president of Zambia. Then with regards to South Africa, the president has announced that local government elections will be held on the 27th of October 2021, and these will be the 6th municipal elections that is being held in South Africa since 1994. And you can see that these features of founding values of constitutional democracy, all of them have actually been achieved in practice. That's why South Africa is regarded as the epitome, or that quintessential or a typical example of how a true constitutional democracy should resemble. We've been having undisturbed periodic elections since 1994. Then the question which I want to pose to you now is, has the response to the COVID-19 pandemic changed the basic constitutional functioning of the IEC? So the IEC forms part of the organs of state that are mentioned in Section 239 of the Constitution. Then what is the difference between a state and a government? A state is a permanent legal entity. A state is the permanent legal entity consisting of a defined territory, a community of people, a legal order, an organized government, and a measure of political identity. These are 5 elements of a state. Remember, in the case of the Independent Electoral Commission versus the Langberg municipality, the court said the IEC does not form part of the government but forms part of the state. If it was forming part of the government, it means it will be under the influence of the national executive. That would amount to the failure to adhere to its independence status that is conferred by the Constitution in terms of Section 181 of the Constitution. So these are the 5 elements of a state. The first one, a specific geographically defined territorial boundary, a community of people living within that territory, a legal order which is accepted by the community and to which that community is subject to, and an organized system of government which is able to uphold the legal order, and a certain measure of separate political identity, which is in terms of international law, one could say it's sovereignty. So the IEC forms part of the organs of state. Then what is a government? The government is the temporary bearer and the political administration of a state authority that represents the state at a particular time, made of, in the context of South Africa, the government is made of the 3 branches of government: the legislature, the executive, and the judiciary, and the 3 spheres of government made of the national, provincial, and local government. And I still continue with my question. Has the response to the COVID-19 pandemic changed the basic constitutional functioning of the IEC? I would like to relate this question with 2 case studies that have happened, and these they relate to national legislation and the Constitution itself. I'm presenting this case study so that one could be able to see the significance of the Constitution, that it is indeed the supreme law of the Republic, and any law or conduct that is inconsistent with it, it is invalid. So in this case study, I'm referring to what happened last year when the COVID-19 was declared a national disaster by the president on the 15th of March 2020. He went to impose the lockdown that came into effect on the 27th of March 2020. And mind you, the IEC has already set its electoral calendar that on March and April, May 2020, it shall hold municipal by-elections. So by-elections are different to municipal elections or local government elections. By-elections are elections that are meant to fill a vacancy within a ward, where a ward councillor who receives a mandate from people within his community is elected to become a ward councillor. Once he resigns, or he dies, or is removed by the municipal council or by his party, or his election or his or her election into councilship is set aside by the court, then there arises a vacancy. That is this is also provided in terms of Section 25 of the Municipal Structures Act. So these elections were meant to fill the vacancies. Then what happened was the coronavirus happened. The president declared the state of disaster and imposed the lockdown. The question was, should the IEC continue with the elections? So in terms of Section 8, Subsection 1 of the Municipal Electoral Act, the IEC has got the right or powers to request the MEC of a particular province to postpone by-elections if it deems that these incoming elections won't be free and fair. So again, in terms of Section 20, Subsection 1 of the Electoral Commissions Act, the IEC can submit or lodge an application before the Electoral Court requesting for the postponement. Then the Electoral Court, in terms of this legislation, can decide on, can review that decision or grant it. So indeed, the Electoral Court decided to postpone municipal by-elections, and it held that the by-elections could be held beyond the 90-day legislated period, but not beyond the 120 days from the date of the order. Then now, look at the difference. Here I'm referring to the Constitution, not the legislation, because the Constitution is the supreme law of the Republic. Currently, as we speak now, there is a constitutional matter that is being presented today. As I was preparing for these notes, I was also checking, but I lost track since I had to do some other things. But I will therefore request you to also follow up after this lecture. We last held our local government elections in 2016. And the Constitution in Section 159, Subsection 1, it provides that the term of municipal councils may be no more than 5 years. And if it's to exceed 5 years, then it should not exceed 90 days. What needs to happen is there has to be elections within 90 days, whether the municipal council is being dissolved by the provincial government or its term expires within 5 years. But within 90 days, there has to be new municipal elections. This is required in terms of Section 159, Subsection 2 of the Constitution. Currently, it means that these new elections that are supposed to be held by this year needs to take place between the 3rd of August and the 3rd of November 2021. And the President, Cyril Ramaphosa, announced that the election date will be the 27th of October 2021, which means it is within the 3rd of August and the 3rd of November. However, the Minister of Cooperative Governance and Traditional Affairs is required by law, particularly Section 24, Subsection 2 of the Municipal Structures Act, to consult with the IEC before making a proclamation. A proclamation is an official announcement that this is the date of elections, and where there is a proclamation is declared, it means the IEC must kickstart all the key electoral activities. It has an electoral calendar. It needs to organize the elections looking at the post-election period, during election period, and a pre-election period. So all these three phases needs to be achieved within the Electoral Commission's calendar and as required by the law. So this proclamation is done by the Ministry of Cooperative Governance in conjunction with the IEC. However, due to the current situation with the battle against COVID-19, isn't it that last year the IEC, using a legislation, requested the Electoral Court to postpone elections? But this time around, because this is a requirement by the Constitution that the new elections must be held within 5 years. It's a different story altogether. Then Section 14, Subsection 4 of the Electoral Commissions Act, it states that the IEC may publish a report on the likelihood that it will be able to ensure that any pending election will be free and fair. Then the question is, with COVID-19 still in our midst, will continue with the 27 October local government elections constitute a free and fair elections? The IEC felt like it's challenged. It is caught between a rock and a hard place. On the 20th of May 2021, the IEC appointed retired Constitutional Court Judge, the former Deputy Chief Justice Dikgang Moseneke, to lead a commission of inquiry on the feasibility of holding free and fair local government elections. The IEC's approach in terms of requesting the former Deputy Chief Justice is more of a cautious approach, because it knows that it's bound to hold the elections as required by the Constitution, but it does not want to decide on its own whether to postpone the elections or to hold them. Then on the 20th of July 2021, the Chief Justice, the former Deputy Chief Justice Moseneke, he published a report of his findings. Then the report, it's slanted towards postponement to no later than February 2022, and that there is a possibility that the October elections might not be free, fair and safe. And again, this will be against the constitutional provision that the elections are supposed to be free and fair. One needs to take note that currently there is no any clear-cut constitutional provision that provides for deferment or postponement of elections. There are two possible ways around this. The first one is either to amend the constitution, and second one is to obtain an order of the Constitutional Court which will permit for the postponement of elections, but in so doing it means the current municipal council's constitutional terms needs to be extended. Imagine the Constitutional Court, it's either it grants a permission that the current constitutional terms of all the democratically elected municipal councils which came into power in 2016 needs to continue serving the people beyond their original constitutional term as provided by Section 159 of the Constitution. Take note of this, that amending this section of the Constitution will require a 75% supermajority by the legislature. The question is, will all the political parties participate in voting for the amendment of this constitutional provision under question? On the 14th of August 2021, the IEC then lodged an application before the Constitutional Court requesting for the postponement of local government elections and requesting that the court must make an order that the current municipal councils should retain their legal authority until having newly elected municipal councils. The truth is, upon the expiration of the current municipal terms as conferred by the Constitution, all the municipal councils' authority won't be legal but illegal. Why? Because their term would have ended, and continuing, it will be against the basic tenets of the Constitution. The IEC it will amount to free and fair, it will amount to no free and fair elections as guaranteed by the Constitution. This is others are
Prof, we're losing you. I think you're closing your mic.
Can you hear me now?
Yes, we can hear you.
Oh, okay. As I was saying, the Constitutional Court said to hear oral arguments from different parties that in order to listen to arguments if whether the elections need to be postponed. My question with you is the postponement constitutional? So yesterday we published an article where we're trying to deliberate on these, but it is actually a very tricky situation because the IEC knows its constitutional mandate and it does not want to breach it. That's why it's requested the former Deputy Chief Justice Dikgang Moseneke to help in terms of presenting a report on the feasibility of holding free and fair elections. Then the report of Chief Justice Moseneke, it tilts towards postponing elections, but again, it also provides its own questions if whether it will be possible. And it suggests that it's either there has to be an amendment of the Constitution or the Constitutional Court itself. It needs to declare that the postponement is legal and that the current municipal councils can continue beyond their constitutional term up until next year. The Constitutional Court is conferred with the right to adjudicate all the constitutional matters. That's why the IEC is playing a safe game, like that we throw the ball into the hands of the Constitutional Court judges and see what is it that they will do. So whether the Concord, whatever decision of the Concord, the IEC has played a very safe game. I guess I've been able to explain how I wanted to present my question, my lecture, but as it stands now, nobody knows if whether this will be constitutional or not. Yeah, I just urge you to follow up with the presentations of today. Thank you so much.
Mr. Mudau.
Yes.
I see how the Constitution is, the Constitutional Court has to decide now whether to
Pilani? Pilani?
Hello, yes?
Yes, no, I don't know if it's just me, but I think we lost you.
Oh yeah, I got I was saying, oh gosh, it actually just escaped my mind right now. The recommendations of how the election should be set, whether they should be free and fair, or whether they'll be postponing, having them right now would mean that they're not free and fair. And also there's also a danger as well of an overreach of power, or when the Constitution is actually amended for the current councillors to actually extend their term in governing. Then, so if their term is extended, then does that mean that the following that the trend of actually extending the term will actually carry on? Isn't that like a danger to democracy in a way? I don't know if my question actually makes any sense, or can you make any sense of it? But do you get the gist of it? Like having to extend right now the current mandate of the councillors because of this situation, is that maybe a dangerous situation that we are putting ourselves into?
Yeah, Pilani. So you have raised a very valid point. So, and this has been happening across Africa, where perhaps the incumbent leaders who do not want to lose the grip of power, what do? It's either they amend the constitution or they request the courts to validate their continued stay in power. And mind you, the purpose of ensuring that we have got local government is to ingrain local democracy, where that element of periodic competitive election will occur. So right now, the Constitutional Court has been put in a very difficult task. And if it decides on postponing the elections, myself personally, I feel like we'll be playing almost a similar game which we often observe in Africa. But we must also take note of the following, that South Africa, since the advent of COVID-19, has had the highest number of infections and the highest number of deaths. And with the Delta variant, and with the possibility of having another variant before December or November, one could see that holding elections could be more risky. You may find that the messaging of stay at home versus the messaging of come out to vote or come to a certain rally will create contested and confusing messages for some communities, and has the potential to harm the public health measures, where many communities cannot join a Zoom rally, nor do we have the mail balloting in SA. You may find that we've got very long queues that require social distancing and marshalling, the likelihood of fear of being marshaled by police, the army, due to repressive control techniques used, and having limited number and location, which means we'll have issues with open air of voting sites. This could likely to result in congestion of people and officials, having limited outdoor, properly ventilated, voting sites that are not actually compliant with the requirements of COVID-19 regulations. You may find that there is a shortage of sprays. Temperature checks do not actually are not sufficient on the day of elections. Everyone at the same ballot booth, requiring to be sanitized after every vote has been casted, which will lengthen the voting processes unless alternatives are secured. But obviously, there is a potential for high risk in handling of the same ballot materials. And again, IEC officials handling multiple voters' documents for verification. And there can also be issues with IEC officials and party monitors, who are also congested trying to count.
Mr. Madao, I'm not sure if this is the right time to come in because we can't hear you. My question is around the fairness and the ability to hold free and fair elections, taking into account that we've known about the current situation that we're in since December 2019 and going into lockdown in March of last year, and being very clear in terms of where we stand with availability of vaccines in Q1 of 2021, and with no clear plan in terms of when we're going to get these vaccines into the country. How can we as citizens and the Concord confidently respond in saying the IEC has left this too late to rush to the Concord and hold the inquiry by Judge or the former Justice Moseneke?
Hello? Oh, sorry, I've been lost for some time. I just rejoined now. I'm not sure whether my presentation after some time we're able to hear it, and I can hear that there is someone who was just posing a question.
I know we heard your presentation. Sorry, okay. We heard your presentation. He posed the question, so he can pose it again.
Yeah. My question, Mr. Modao, is around the holding or the inability to hold free and fair elections in view of what we know around COVID and lockdown. So as a global community, we've known about the presence of COVID since late 2019. The country has been in lockdown for a considerable amount of time, over 400 days to be exact, and close on 600 if I'm not mistaken. We've known about the lack of or the availability of vaccines. I mean, one would hesitate to not mention the missing 500 million. And how is it then fair of the IEC to hold a crucial review so late in 2021 and so close to the elections, and then say that the big problem they foresee is the holding of free and fair elections, yet they've known about this thing for so long. And it has been clear since the first quarter of this year that there's potential problems. And it is their constitutional duty to ensure that elections are held within the specified period. And in line with what Pilani was asking, what are we supposed to do as an electorate, knowing that all of these problems have knock-on effect? Is it fair then to use the argument that we cannot foresee free and fair elections, and this being justified by a review of a former justice? For me, it doesn't add up, and I just want to hear your views constitutionally. Where do we stand moving forward?
Oh, okay. Thanks for your question. You know, the IEC, I think it cannot just is not supposed to fully assume the blame in terms of failing to hold elections as required by the Constitution. I mean, or within the given time period. The situation on the ground, I think one could mainly blame the national executive for failing to fully enforce the lockdown regulations, ensuring that people actually comply with the requirements for social distancing, sanitizing, and everything. Because the elections are held once, but the governance of the situation on the ground with regards to COVID-19 falls squarely on the government itself. We know that there is also a parallel structure that comprises of initially it was certain cabinet ministers, and later it was reported to be all cabinet ministers, called the National Command, the National Coronavirus Command Council, the NCCC, which was taking decisions on behalf of South Africa's government. It was intended to serve as a consultative and coordinating forum to ensure the effective communication over the national response to COVID-19. But you may find that it's duplicating its roles with the National Disaster Management Center. So at the end of the day, the failure to ensure that the IEC is able to hold or to create on its own conducive environments that could ensure that there are free and fair elections do not fall on the IEC itself, but the government. It's just that the IEC now, it is bound by law to fulfill its mandate, but I don't think it is actually solely the IEC to be blamed. Perhaps one could say, yes, they should have launched the application before the Constitutional Court long ago. We must take note that there are various phases of the wave where the cases, they decrease, and they increase, and we're all hopeful that by the time when the elections, the election date is approaching, at least the cases would have dropped down, and we will be able to hold the conducive elections. But surely it is the government that has failed. Now the Court is now required to decide on a very, very dangerous case. This matter has got the possibility of changing the constitutional structure of South Africa, because if it happens, then we find that the COVID-19 or another national disaster occurs in future. We will use the judgment as a precedent, and since it's taken by the Constitutional Court, which is the highest court in the land that adjudicates on constitutional matters, then I see that we can, in this respect, put our constitutional democracy in tatters. My recommendation or my view is that let the elections be held, but instead of being held on one day where people will be congested, let them perhaps be held within 2 to 3 days, so that those who are voting could be managed in order to have their way within the voting station and limit the risk of being infected. So yeah, that's my opinion so far.
Yeah, you know what, Mr. Mutau, I also thought of the same thing. The Americans also went to elections in the peak of the of the pandemic, and they were able to actually do it. And in their way, the way that they do it is that they do it like in a weekly. So it's actually like election week, and you can go in on certain days, and you don't actually congest on it. So yeah, that'll be actually the best way to actually do it and make sure that we safeguard our democracy. I also thought of something like that too.
Oh, all right. Yeah. Thanks a lot for conveying the same view.
Mr. Mudau, sorry, before anyone comes in, while we're on this topic, my issue or the concern that I'm seeing is we're now giving Parliament and the Concord a very short window in which to decide such crucial matters. And I agree with you. They're not the ones to blame, so to speak. My question is rather, is it fair to say in this 2-month period, we need to decide on this matter as a country and not link it to the recommendation that has just been tabled, that we do it over a period of 7 days and allow the Constitutional Court to determine that in advance, as opposed to putting ourselves into a corner where we're now saying make constitutional amendments or possibly make constitutional amendments in less than 2 months. How fair is it? And should we be not looking at a position where we hold the IEC accountable because it's their constitutional duty to ensure these things happen in time?
Yeah. Take note of these, that there are conflicting constitutional duties of the IEC here. In terms of Section 159, the IEC must ensure that it holds elections after the constitutional term of the previous municipal council has expired. But it needs again to ensure that when holding elections, they are free and fair. And apart from the constitutional provisions, even an ample of legislation requires that the IEC, more in particular Section 4 of the Electoral Commissions Act, which stipulates one of the key functions of the IEC, is that it needs to create conditions that are conducive to free and fair elections. It is impossible to hold free and fair elections in this current situation. Other smaller political parties which do not have access to digital devices, or rural people in rural areas where digital technology is distantly slim, and them too, they're entitled to vote. And again, one of the duties of the IEC is to promote voter education, and much of the voter education programs are conducted through physical contact sessions, holding them in public communities or halls or under the trees, wherever. It will amount to also a breach of lockdown regulations. So you can see that these are competing constitutional mandates of the IEC. You cannot choose one over the other. I guess they need to be reconciled. Then how do you reconcile such things? I don't know. So does the IEC, not even the deputy, the former deputy chief justice who drafted the report. That's why they just said, let's just throw everything to the constitutional court. We'll see how the judges, they are able to adjudicate on this matter. But it's a very crucial case which could set a very good or a bad precedent. But the likelihood of postponement, it can also have implications of having the national and provincial elections that are held concurrently to be postponed one day in the near future, because nobody knows if whether COVID-19 will end by May next year, where everyone is saying let the elections be held by May next year. Or there could be another national disaster which could be worse than COVID-19, and you may find that holding elections, it becomes even more worse. It means the ones who are in the grip of power at national level, they've got the chance to stretch their term beyond their constitutional mandate. And mind you, in the context of Africa, we've seen that other countries were battling with Ebola and other health issues. They've also used national disasters to postpone elections. In the DRC, we've seen that even if it's a human cause where there are some wars in certain parts of the country, they just decide that let the Constitutional Court declare that the term of office will continue up until the conditions are suitable in a certain part of the region, although the entire country is not actually under siege or under attack. So now, since it's a nationwide issue where municipal elections needs to be held, then I guess it is indeed a very tough situation. I actually I don't know how I could recommend, but if it was to be held with in more than 2 days, or at least 2 days, trying to ensure that the voters are able to come in and vote in a very safe manner, I guess could be possible. But postponing elections and again holding them in the current situation, I guess it's a very dangerous situation as well.
Nonhlanhla, do you have a question? Well, I can't see who else has questions.
Hi, ma'am. It's Alice.
Yes, hello.
Oh, yes, Alice.
Nonhlanhla.
Alice name for a while. Yes, please, Alice, carry on. Alice or Nonhlanhla?
Thank you, ma'am. Oh,
I don't. Just go ahead.
LS, are you starting?
oh, yes. No, you can start. It's okay.
Okay. I do hear that there are problems and which are also confusing to me. Okay. Let me just put a hypothetical question rather for me to understand. Let's say if elections are not held on the 27th of October, for whatever reasons related to the pandemic, would it then later call for Electoral Act amendment and Constitution amendment, or would it then call for a series of court cases against IEC and whoever is responsible, be it the Nkosazana or whoever? Maybe if I can just get a hypothetical answer to that, to me, some of the confusions will be clarified.
Oh, okay.
Did you understand me though?
Yes, I think I understood you. So,
okay.
One part you speak of for having continuous court cases being presented before the Constitutional Court.
Yes.
I will reiterate this, that the IEC played a safer game by involving the Constitutional Court. I gave an example of the by-elections that were postponed last year 3 times by the Electoral Court, which was relying on the I think they were relying on the Electoral Commission's Act, which provides for such possibilities for by-elections to be postponed. But now, here, it's a constitutional provision that within 5 years, and within 5 years after the expiry of the term of the municipal council, there has to be new elections. This is a constitutional provision that is binding on everyone. It's different from that previous case. And now, involving the Constitutional Court is strategic instead of the Electoral Court, because the Electoral Court does not have the right to deal with the constitutional matters. It is the Constitutional Court that needs to do so. Then I will refer you to section 167, subsection 3 of the Constitution, where it deals with the powers of the Constitutional Court. It states that the Constitutional Court is the highest court in all constitutional matters and may decide only constitutional matters and makes the final decision whether a matter is a constitutional matter or whether an issue is connected with a decision on a constitutional matter. And which means postponing the term of the current municipal council is a constitutional matter because it affects the expired constitutional term of the municipal councils. So will postponing them be constitutional or not? So that's why the IEC played a safer game, put it into the hands of the Constitutional Court, which in terms of the Constitution, it decides a constitutional matter and makes a final decision. Meaning, I don't think there is a high likelihood of having continuous court cases being presented before the Constitutional Court, because this is one matter that, although it's arising for the first time, the Constitutional Court makes one, if it makes one binding and final decision on a certain matter, that's final, that's binding. The IEC will need to follow the decision of the Constitutional Court.
Okay, thank you.
All right.
Was that Alice?
Thank you, Prof. Mr. Mudau, I wanted to, I'm not sure if I will be right if I say I feel the IEC was a bit irresponsible, for lack of a better word. I don't know which other word to say to them, to use describing them, because like I think it's Sandile who spoke about this. People knew about COVID-19 like for the past almost 2 years, and we are in almost a fourth wave. So how do you bring this matter in court, whereas there are few months left of us for us to vote? And we know that how the government has been working closely with the Department of Health and some experts. The reason why I'm saying this, I want to touch on the issue of herd immunity. Herd immunity in a sense that people are busy being vaccinated. And when we reach a level where a lot of people are vaccinated, then we reach herd immunity. That can also be used as a support for the elections to be held. But I feel there is a lack of accountability on the side of IEC, because you can't sit for 2 years knowing that the elections are being held after every 5 years, and we are sitting with this thing, even if you don't know that COVID is going to go tomorrow, but you can tell that this is continuous. We are going from first wave to second wave. Probably by second wave, the IEC should have started to say, guys, we've got this matter, and then maybe they try some discussions, consult experts, and then see what can be done. And also, maybe the issue of the 500 billion that just disappeared, maybe we would have been vaccinated long time ago, then we know that we've maintained herd immunity, because other countries now, they are attending soccer in the stadiums, they are doing well. So this thing is possible. I feel that they are just trying to find problems, because that's how it is. In South Africa, you don't be held accountable when you are in a government space and whatever. You just do as you please. They don't care about the people, because we need to move on. We need to carry on. We cannot be using COVID-19 even now to say we need to find measures. We need to put measures in place to say from here, where are we going? You know? So hence I said they should have prioritized herd immunity. And then we know that when a lot of people are vaccinated, then people can go in and gather. So another thing is you talked about a breaking down of voting, like people will come in maybe for a week or so. Does the Constitution support that? Will that be viable? And will that also constitute a free and fair elections if we were to consider that model? Thank you.
No, all right. Yeah, thanks a lot for your input. I will respond as follows that yeah, one could say the IEC is to be partially blamed because it just waited for some time and when things were not according to how the IEC expected, then they panicked, invoking the section which says they could present a report that that determines whether the incoming elections will be free and fair. But still, if you look at the situation in South Africa, it's badly unique across all the countries in Africa. We are at a different level in terms of battling with COVID-19. One thing for sure, there is a part where I indicated in my presentation that the president announced that the elections will be held on the 27th of October 2021. Although the president might have made an announcement, I'm yet to be corrected, but the Minister of Cooperative Governance and Traditional Affairs is then required in terms of Section 24, Subsection 2 of the Municipal Structures Act to officially make a proclamation that this is the date in which the elections will be held. Upon that proclamation, it means all the electoral activities need to commence, then the IEC need to organize the elections. So, and these activities are in three phases: pre-election, during election, and post-election. And right now, the IEC has not yet engaged in any of these key electoral activities except lodging that application before court stating that it does not think like the elections will be free and fair. And again, blaming the IEC for the failure to hold these elections, I think at myself, I think like it is a bit incorrect. The one whom we need to fully blame, it is the government that has failed to manage the COVID-19. Mind you, we're in a we're facing a possibility of a fourth wave, and the IEC has nothing to do with the recurring waves, but the government that is imposing very conflicted, numerous lockdown regulations and directives going back and forth in terms of decision making. The decisions of the government are the ones which are affecting other institutions, state institutions from functioning, including the IEC. If the government was actually able to manage the COVID-19 like what we've seen by other governments, especially in the Western world, the IEC could have been in a better position to promote the conditions that are conducive to free and fair elections. But these requirement as required by Section 4 of the Electoral Commissions Act, it does not relate to human health. No, it refers to how people will be able to vote without fear of perhaps being attacked in the voting stations or being blocked from leaving their homes or reaching the voting station, or when they go to the voting station they find that there is a lack of voting materials, more in particular the ballot papers, or when the people are voting they're being intimidated, being given the order on whom to vote. So these are the conditions which the IEC is supposed to deal with in order to ensure that the elections are free and fair. The one that actually deals with the human health emanates largely from the National Disaster Management Act that confers the Minister of Cooperative Governance and Traditional Affairs together with other cabinet ministers that they need to deal with this national disaster. Meaning, before you could look at elections, look at the root cause of what made the elections not to be possible. The failure by the government to fully implement the law. Mind you, all these directives, that's why they're being implemented, or they're being formulated and implemented back and forth, being conflicted, being misdirected, is because there is inconsistency in terms of the government decision making. You have also seen how our government, in particular cabinet ministers, are responding to problematic situations in the country. For the recent example is the situation where KwaZulu-Natal and some parts of Gauteng were engulfed by violence, supposedly by people who are supporting former President Jacob Zuma. One cabinet minister issues a different announcement that contradicts the other. This is what they've been doing in terms of dealing with COVID-19. So to me, it is mainly the government that is to be blamed than the IEC. I think the second question, can you remind me of the second question that you have posed, please? Sorry that I forgot.
No, it's okay. It was very long. I was asking that because you said you would suggest maybe we get to vote within a week or like they stretch the days. Will that be supported by the law now so that we avoid to going back to court to say this? Will it constitute a free and fair election if they were to implement them?
Oh, okay. So since the Constitutional Court is required to decide on a matter that is totally unconstitutional, but if the Constitutional Court itself makes that final binding decision, everything that it says, it needs to be implemented. Then my view is, as long as it is the Constitutional Court that also decides on having elections being held in 2 or more days, it will still be constitutional within the context of its decision. And don't forget that since last year, there are some cases even before court that people are challenging the constitutionality of lockdown regulations, including the legality, legitimacy, and accountability of the National Coronavirus Command Council. But what happened was that the courts dismissed all these challenges, upholding the president's argument that the cabinet could arrange itself in any manner that it deems fit, and even some of the decisions that people could clearly perceive that they are unconstitutional or they are violating people's right, but may find that the government are actually in support of this, including the different lockdown regulations, meaning as long as it is the court that decides on this, it needs to be applicable and implementable. And therefore, even the decision to hold elections within 2 or more days, it could still have effect or be binding in law as long as the Constitutional Court decides. Why? Because when the court decides in favor of the government or in favor of anything, as long as it relates to COVID-19, it continuously cites that we are facing a very strange, difficult circumstances that we have never encountered before. So it's either we compromise, we bargain, we do this instead of being loath or reluctant to do something, because the situation is totally different. We are not in the normal health situation like during the pre-COVID-19 era. It's a new life altogether. I think it could be possible in this respect. Thank you.
Okay, Mr. Mudau, sorry for the dialogue. One last thing. You sound nervous about the amendment of the Constitution. And like the way you say it, or if it get to be changed, then you see a problem as being like other countries. Don't you think that that is a problem? Because at some point, I'm sure the Constitution will be challenged and maybe it might end up being amended, because if you can check the way we would have cases that comes through and really change the law. Are you against the amendment?
Oh, okay. Firstly, I would like to confirm with you if whether the page of the
sorry, Mr. Mudau, I'm so sorry to disturb. Can I come in? Hello,
okay,
Mr.
yes,
Mudau, can I
yes.
just come for a second? I just want to know if the lecture is over, because I mean the conversation can go on between the other student, whoever's got the question. There's other urgent things I think that we need to discuss regarding the upcoming exams and the module content. I just wanted one question. Okay, the first one is I wanted to know if the actual lecture is over, and the second one is if there's going to be a revision class before the exams actually takes place. I'm so sorry to disturb, though. I apologize to the student who asked the question.
All right, but firstly, I would like to state that the lecture is not yet over. And I don't think the questions that are being posed by other students are actually not important. Every question that a student asks is because they need clarity. And I'm engaging with other students because this actually forms part of the lecture, what I wanted to teach. And the questions that are being posed, I feel like they actually form part of the entire as supposed to be. So labeling other questions or repeated questions in terms of finding clarity as if they are not actually important, I don't think it is actually correct. With regards to the question which you've posed currently, I'm not at a position to just
Prof, we can't hear you.
the lecture. I just wish that Prof. Liston could be able to help you with the question which you just recently posed.
Yeah, sorry, what was that question? I was trying to respond to a student. Repeat the question, please.
Sorry, my question was if we are going to probably convene revision class just before the exam, if there's a possibility. Thank you.
I think that we will do so. I am prepared, and I think I probably be the best time because that is a week before the exam, if the exam stays 6th of September. So yes, I am prepared to do a revision lecture next Friday. Let's say we start at 3 o'clock, like we have been doing. I don't expect Mudao to if he's busy. I know Prof. Shai won't be participating in the lecture either. So yes, I will deliver a revision lecture. Did you hear that?
Yes, I did most
Yes,
of it. I did
Okay.
hear. As
So
I
the answer
understand,
is
it's
yes.
going to probably be next week Friday. Thank you so much. I really appreciate it. Thanks.
Okay. Were there other questions that we were still discussing?
I have a question.
Yes.
I just want to find out on your lecture like today, you indicated that okay, public protectors findings are binding to the executive. I know if I'm not mistaken, when I read on the study guide, I think chapter 9 institutions findings before were like those chapter 9 institution findings were just recommendations and they're not binding to the president up until the one of Tulima Donsela was after Tulima Donsela's those things were changed. So now I just want to know with the other institutions now, their recommendations will remain merely recommendations up until also they are changed otherwise by the Constitution.
Okay, so what has been declared by the Constitutional Court in light of the Thuli Madonsela finding in the Nkandla case is that we should use the terminology of the public protector's a real recommendation, because that was the word, that word recommendation should actually be reconstrued as a finding that is legally binding and must be implemented. So without to change the Constitution, the court have given more depth interpretation and 82 of the Constitution, and we therefore need to understand that the decisions of the public protector must be complied with as though they are court decisions, even though they're not court decisions. And the only binding is if they have been formally set aside by court. So the terminology of whether it's a recommendation or a finding is not material. We need to interpret the word recommendation as being a finding that is based on an investigation that is solid and sound and without any irrationality. Is that okay?
Does that now apply to other Chapter 9 institutions as well?
Not yet. No, you see, that's what's so interesting, that it doesn't automatically apply to the recommendations of the Human Rights Commission or the Commission for Gender Equality or the Auditor General, for example. All of those are still recommendations. But the idea has always been that all of these reports issued by the Human Rights Commission, Commission for Gender Equality, Auditor General, are sent to the National Assembly, and the National Assembly should hold whoever accountable. So, for example, in the Limpopo province, if the Human Rights Commission is busy with its investigation into the fact that there are still pit latrines and not proper toilets in the schools, those recommendations that are sent to Parliament saying that there should be proper toilets, Parliament should be taking a more proactive role and saying to the Minister of Education, Minister of Social Welfare, we've received this report. This issue falls within your portfolio, and we think you are not doing enough. You need to tell us what you're going to do. So the idea is ultimately for all of these recommendations to be implementable and binding immediately. But there's never been a case yet relating to any of the other Chapter 9 institutions where it's been unambiguously declared that they are final and binding immediately. But I think the idea has been now sort of the seeds of the idea have been sown that all of these institutions, their decisions are not just writing on a piece of paper that can be ignored. They have to be taken seriously for the interests of everyone in society. Yeah, so that is my answers, that the others are not yet formally binding, but I think that our National Assembly has realized that they have to take each report that they receive as seriously as possible, because otherwise there's going to be constant litigation against the Speaker of the National Assembly for not doing enough, which is precisely why the economic freedom fighters were forced to go to court in the Nkandla case. And we know that that's unnecessary money, money being wasted going to court when the National Assembly already knows that it is supposed to be providing full and proper oversight, making sure that the ministers responsible for whatever portfolio it is actually doing his or her job effectively.
Sorry, Prof, can I just interject, please?
Yes.
My name is Gabriel. I want to respond to Lidu Mabusalet's question. I think there are varying degrees of how the law is being implemented. I'll use the Auditor General, for instance. Previously, the Auditor General will audit and report to Parliament, and that would be all. But in their audit, whatever financial mismanagement or any kind of mismanagement that they elicit, they would try to teach or to educate maybe the municipality or the government entity about how things should be done. But since last year, beginning of April, the Public Audit Act has been amended. Now, you may find that maybe a certain municipality has been doing things wrong and being repeatedly told how to do things right. If now the Public Audit Act has given teeth to the Auditor General to bite, that the person, the CFO or the municipal manager or whoever is the head of the finances in a particular institution will be issued with a certificate of debt, meaning that that person must pay the money which has been mismanaged. If the person doesn't do that, it becomes a huge litigation that goes to court. So for me, some recommendations are actually binding. I'm talking about the institution that I understand fairly well, the Auditor General. Thank you.
Yes, look, I think that my starting point when I was starting the lecture was just trying to bring across the fact that these Chapter 9 institutions are all designed to radically transform our society and ensure the best interests of every single person living in the country, and therefore each individual Chapter 9 institution is there to monitor at all times what the government is doing and be able to report on that, so that a remedy or some kind of rectification can immediately take place. So the case of the Auditor General, for I think that coming across that there has to be better financial management of municipalities and of all government institutions, but there is something lacking in the system, which I think I've referred to before, which I attribute to colonization, where colonizers imposed their own systems on us, and that's sort of why we are resistant to those systems. So that's why we how do I say it, internalize these institutions and their role in society. So I think things get better and is a very slow process, because people are not familiar with these institutions and the importance of these institutions, and they haven't been taken seriously up until now. So I don't know if that is exactly answering your question, because I was busy responding to a student at the time. Your last point, you said something about the Auditor General's Act has been amended, did you say?
Yes, I did, Prof. It has been amended.
Sorry, and the point you were making about that was to sort of give them more teeth.
Precisely.
Yes. Okay. Yes. No. So then I was definitely on the right track. That is precisely the thing, is that up until now, we've had all these institutions that are using taxpayers' money and not being able to do what they do. So just in the EFF, the public protector got more teeth, if you will. There was then a parallel process where they realized the Auditor General plays such a fundamental role in our society because we have limited resources and such a growing population who all need education, healthcare, social security, and that's why they've had to give the Auditor General more teeth. So yes, we are seeing that internalization, as I referred to earlier, of the importance of these Chapter 9 institutions and therefore making them stronger, because up until now, we've never seen any them are going to be able to bite, and it's not going to be a situation of the dog with the teeth that only barks but cannot do anything more. Yeah, so I don't have a final answer. Just I agree with you that we have reached the point where we have to give these institutions more power, because otherwise, what is the point of them? Except to just siphon off government or taxpayers' money.
And for me, such developments confirm the very thing that you said earlier this year, that our constitution is a progressive constitution. So these things are eventually going to be added onto the constitution. So it progresses. It's not like fixed into a certain point.
Yes, absolutely. And I actually want to quickly use this point, that exact idea, to add to Mr. Mudau's lecture on the current Constitutional Court case about whether the Constitution needs to be amended to allow for a deferral of the elections. And what keeps going through my mind is the fact that you remember I told you how South Africa operates within the broader global community. And interestingly, South Africa is one of the countries that is deeply embedded in the African Union. And there's a treaty that has been adopted by the African Union called the Malibu Protocol, which actually says, and this relates to one of our earlier lectures, that if within 6 months the Constitution is amended to change the terms of that election that would have been, it could constitute an unconstitutional change of government. So I think that the current case is so interesting because we are now seeing in real terms how our Constitutional Court is going to have to look at all the evidence presented, as well as the obligations that we as a sovereign state have voluntarily taken on in trying to decide how best to proceed with the argument that the elections should be postponed. And my quick sort of summary in my mind is, I think that when Dikgang Moseneke made his recommendation that the elections be postponed, having read his most recent book called cases like the inquiry into the Life Esidimeni situation, where a whole lot of disabled people went missing and died. And I think that is one of the reasons why he made a very cautious recommendation, saying let's rather put life ahead of the elections, and he tried, therefore, to make a rational decision. In other words, what is the power conferred on him? He's been asked to carefully weigh whether the elections should be held in light of the COVID pandemic. And so he made a rational recommendation, but there seems to be enough countervailing evidence, so opposing evidence to the effect that we could in fact and should in fact continue with the elections as is, because already we stand in long queues for COVID vaccinations. We stand in long queues waiting to go into a shop, for example. So how is that different from standing in? There isn't really, to my mind, a very significant risk associated with holding the elections during a pandemic. Like Mr. Mudau was saying, other African countries have managed. We saw, as I think it was Pilani might have been the one who said, we saw the United States of America having an election. So the Constitutional Court is probably going to end up saying we actually don't have the right or the power to change the election date, and there are sufficient safeguards to enable the elections to go ahead as planned, because otherwise we might be violating other international obligations that we've undertaken. So I know that was a long answer, and I don't know if Mr. Mudau agrees with me, but that's what I want you to realize, is that we don't operate in a vacuum. We operate in terms of not just our domestic constitution, but also all the international. In the Zuma case, the various respondents were asked to make submissions about how international law impacts on the Zuma case, because we are a state that respects international law, and where our constitution says when the court makes any decision, it must consider international law. So that's my little bit of answer that I think is a sort of a dovetail into Mr. Mudau's lecture. Is that okay? I hope you could hear me.
Hello, ma'am. Can you hear me?
Hello? Yes, I can hear you. Did you all hear me?
I can hear you.
Yes, I did. Okay, that's good. I thought I was talking to myself.
Yes, but you are breaking in between, ma'am, but we could figure most of it. I don't know if there's any more students that have content-related questions. My question is not content-related, so I don't want to interject if there's any more questions that would deal with the content, or whether I can just proceed to ask my question.
I'm happy for you to ask it. I don't know if Mr. Mudau's got a different view, but there don't seem to be many more content-related questions, I don't think. Are you Sunette? Sorry, who are
Sunay, yes.
Yes, Sunay. Oh, okay, yes. So you are the second to last hand, so I think it's fine if you ask your question.
Okay, if you break up, then I'm going to ask the question in the email as well, but maybe I hear the response. Ma'am, I have asked before if we can please just get a memo of the assignments. I realize the assignments are not going to be finished marking in time, and it is a train smash that we're writing on the 6th, but that's the way it is. We are writing on the 6th. But if we could please just get the memos of the assignments, then we can work through it by ourselves and compare it with our own answers. Even if we don't have the marks, then at least we can see this is how the question is supposed to be answered, or for the multiple choice question, this is the reason why it's this option or this option. So if we can please have those memos, I'd be really happy. Then that would assist at least.
Yes. And I did plan for you to get them in the next few days. I had only been waiting because there were so many students who couldn't submit and have been submitting by email. So I didn't want to release that document too soon, but I have actually prepared it. I will most certainly make sure you get it, I would say by Monday at the latest.
Okay, that would be wonderful.
Yes, no, I know. I'm sorry. I just didn't want to send out too early, and people are just copying and pasting.
Okay, ma'am, and then you were breaking while this question was being answered, so I only heard half of it. Just a confirmation. You're saying the format of the exam is it's 25 questions with true or false answers, which you need to motivate for 2 points. So then it's 25 questions times 3 points brings you to 75, and then there's a long 25-point essay question.
Absolutely.
And then we do it on a Word document like we did our assignment 2. You save it as a PDF and then you submit it on the link. So
that's exactly what I have in mind. But I do realize there are people who are going to want to write by hand, which is also fine.
Okay, but what
that's
I
just
mean,
more difficult.
It's not a system generated that you have to click on the screen or complete in this little block. You can free write on a Word document or on a document.
On a document as though you do answering assignment 2.
Okay, wonderful.
Yes.
And then, ma'am,
just
can
I ask you a
question? Can I finish up quickly? Can I finish up quickly?
Okay.
A lot of the people asked about the exam timetable. I just want to give a tip, something that worked with me. If you go onto My UNISA and you go under My Admin, there's 3 options. The bottom one says exam timetable. If you go in on exam timetable, you will see your subjects lying there. But there's a little block there that says email timetable. Now, I've been trying that for some time now, and it emails it to you, but it just says as per department requirements. But I actually came round now. So it's the same with us. We also need a proper timetable with a UNISA logo on it to apply for study leave. But if you do it through that way, it seems that it's in order now. You can actually get your timetable on a UNISA letterhead.
Okay, thank you.
All right. Thank you very much, ma'am.
Thank you. So was that Ray Shole?
Yeah, yes, I'm here. Hello, how are you?
Yes.
My question is actually going back to the issue of the probably constitutional amendment or in relation to this case that is going on. What effect will it have? Because the statistics have shown that the greater part of the South African population doesn't go to the votes. And with local elections, even worse. So we're talking approximately maybe 3 million or less people. I don't have the actual stats, but from what you said earlier, in terms of how we have actually acclimatized with the COVID-19, it's actually possible that we can still keeping the fingers crossed that the Constitutional Court doesn't come in with recommendations what you call can continue, given the number of people that actually go and vote vis-a-vis the actual number of people on the voters' roll.
Yes, I like that comment, and I'm inclined to agree with you that we really do have to be realistic and understand that it isn't huge numbers of people that are going to be voting. The majority of our population is, I think, under 18 anyway. So it's not a huge number that will be voting. So I don't know if Mr. Mudau agrees with your proposal or your statement, because I certainly do. I think that that's a very valid point number. Reshole, was that you then, or was it someone else who asked?
No, it was me.
So have you asked your question?
I'm struggling to hear your response on the other side. No, mine was just more of a statement than a question itself, to say, given the statistics of the number of people that go to the votes, there is practically no need for the CC and political parties to say we can't go due to COVID by virtue of the number of people that actually turn out to the election. Because if it's less than 3 million, already we know the regulations, we know the social distancing and all these things. Also going back to the issue of maybe if we're giving 2 to 3 days of voting, then it's doable. Because even before, there was a day of special votes, and then a day after, then it's normal 1 day, full day up to 12 o'clock or 11 o'clock for the vote, and then we continue. Thank you.
Yes. So I don't know if you can hear me, but I agree entirely with you.
I do hear you.
Yes, I agree. Lesejo?
Ma'am, regarding the examination. Regarding the examination,
Yes.
because you said that we are allowed to write on a paper, and as far as I'm concerned, we didn't get
Exam
pads. So are we allowed to buy our own exam pads and write the examination?
Yes, we don't care what the paper looks like. It doesn't matter. It can be any paper.
Thank you.
Any other questions?
I do have one question.
Oh, then Daniel, is that you? Yes, carry on.
For the fact that we're writing this examination, are we going to have to add a plagiarism statement or something like that?
No, I'm not going to expect that. I think there might be somewhere where you have to click and say you will make sure that you don't plagiarize in the exam, but I don't expect you to add a document that's a plagiarism declaration to the exam paper.
Thank you.
You're already, under enough stress, and I've tried to make the paper, the draft paper, such that you can't actually just plagiarize, because I want to see something from you that's your own. Yeah, so that answer? Mahlatse?
My question is, like, what type of exam are we going to write? Is it a multiple choice, or is it a written and at the same time a multiple choice?
Okay, no, you must have missed Sunay's question. It is 25 true or false questions, but you have to explain and motivate and justify your answer. So that's 75 marks, and then an essay for 25 marks.
Hello, ma'am.
Yes.
Do we need to reference each and every question on the multiple choice?
Look,
Or
that's
what's the
where you
process?
get your marks from, because when you say this statement is false, you immediately need to say the statement is false, because in paragraph 23 of the case of EFF versus Speaker of the National Assembly 2016, Chief Justice Mogoeng said, the rule of law is supreme. That, so your reference is in your answer, because in law you can't really say anything without having evidence to substantiate it.
Okay.
So that's where for the true and false, your answer, your reference is your answer. And you don't then need to have references at the end again because you've already given me your reference. Or your statement might be where you might say true. The reason is because Section 3 of the Constitution, as read with Section 28, provides that, whatever it provides. And then for the essay, I would like footnotes, but that's because the College of Law has chosen the footnote style, but it's also perfectly possible to write your essay where you say, the rule of law means that everyone is equal before the law. And then you have in a bracket afterwards, Albert Dicey said this in 1683, or I can't even remember when he said it, and it has been confirmed in Section 1, Subsection C of the South African Constitution. So you see, that's what I mean is by authority and referencing. You can do it in the answer itself, and then there's no need to actually have a reference list at the end. Or if you, but except if you are going to use the textbook, you need to say on page 73 of the textbook. You can't just say the textbook says, because how am I going to find where it says that to agree with you or disagree with you?
Okay, no, loud and clear. Thank you very much for that information, ma'am.
Ma'am, can I ask you last question? Because we have to provide a page number. So are we allowed to page through the study guide or the prescribed book?
Yes, and I say that because you've got 4 hours. So you can't copy and paste exactly what the textbook says for your whole answer, but you can say, and then that's part of the purpose is if you've studied before, you know where to look in the textbook for the answer. And so that's part of where we're assessing that you actually have already gone through the material because you know exactly where to go in the book to find the relevant part. And you can say on page 163 of the textbook, the authors assert that whatever that it is. So you actually have time to look at the textbook, but don't just sit and copy and paste whole pages out of the textbook and think you'll get away with it.
Okay.
Thank you so much.
All right, I think we're sort of done, and I know that we now really are just having a question and answer session. Are there any more questions though? Tato or Nonhlanhla?
I think I'm on mute. Okay. Hi, ma'am. I just wanted to ask, how in depth do we have to go with the reasons for the multiple choice questions? Do you have to, like, for example, do you have both, you know, quote a section from any law as well as a case law, or is it just, you know, a brief answer?
Look, some of them can be very brief. If I think about some of the questions that I've provisionally set, the answer might be as simple as saying false. The main source of constitutional law is not legislation itself. Full stop. You know, that it can be as short as that, and you'll get your 2 marks and your mark for saying true or false, whichever it was supposed to be. So that they don't have to be long and detailed, as long as they convince the marker that you actually understand the question and have a proper answer.
Okay. Whew, all right. Okay. Thank you, ma'am.
No, I know. Don't panic, though. I mean, you must just think you're having an argument with your friend, and your friend says one thing, and you say, no, that's not true, because in the case of Langeberg municipality, it was held that the IEC is entirely independent from government. You know, that kind of thing.
Okay.
Yeah.
Okay. All right. Thank you, ma'am.
All right. Shannon, are you?
Hi, ma'am.
Yes.
Can you hear me?
I can.
I just wanted to find out what type of essay questions can we expect in the exam.
I will say it's one that I've never asked before, only because I've tried to make it a very general question that covers a large section of the work, so that I can see that you understand the essence of constitutional law. In other words, what is constitutional law really about? Democracy, a supreme constitution, the rule of law, accountability, and how do we ensure all of these things? We have a public protector to hold the executive accountable. We have the legislature is empowered to make laws, the executive must implement those laws, but the judiciary right to declare law or conduct invalid, because we've specifically empowered the judiciary to do that. And then you can use any case for that kind of a statement. So I'm trying to actually make you show that you know everything, but can get to the point of each thing and make just a convincing essay that you show that you understand what constitutional law is all about and why and how it works and how it is supposed to work and where there are failings, for example. So because there isn't an answer that, there's no single answer. I don't really care what you say, it's how convincing you are in your interpretation of that question and the answer you give.
Okay, thank you, ma'am. One more thing. I just wanted to find out if you will be able to do like a session when you do the revision, maybe on the footnotes or like in text referencing, just to refresh us.
Okay, I thought I just did, but yes, I can do it again. Yeah.
Okay, thank you.
Okay.
Nontantra. Hello,
Yes.
ma'am.
Hi, Prof.
Yes.
Speaking.
Yes, who? Nontantra, okay.
Nontantra, yes.
Okay, ma'am. Thank you for relieving me here. I was shivering and shaking about the referencing thing and all. I've got two questions, one content related and one exam related. Can now, as we speak, independent candidates stand for election without being part of a political party? That is one. The second one is on examination. Prof. Mudau's email reads, this date is not subject to any amendment and or extension due to the finalization of the exam timetable, okay? So can we go to bed this weekend knowing that we are indeed writing on the 6th of September without any hope that there's going to be extension?
I'm going to answer
based on the email.
Yes.
Based on the email, because this is the final email.
Yeah, look, I've seen absolutely no evidence of any attempt to change the date by university management or college management. So you go to sleep tonight knowing that in 2 weeks' time, 2 weeks' time, you're writing constitutional law.
All right.
And as for the first question, yes. I mean, equally, the authority now is, in terms of the New Nation Movement case, it is clear that any individual person or association that is not a registered political party can stand for election in the national and provincial elections. So that is now unambiguous. well, yes, I think because the law is already probably almost finished being drafted, the case has made that the situation. All we're waiting for is a law to that effect, but the essence is that it is actually, that is what the court said has to be made clear in legislation. So we can assume for right now, since we're not about to have a national or provincial election, that you can say, yes, the legislation is in the process of being drafted, and there is no doubt that that legislation will allow individuals and associations to participate equally. So you can say yes.
Okay. Thank you. Thank you.
Right. Mahlatse, are you back, or is it Tato?
Ma'am, I want to ask if on the essay question, how many pages do we write there, or I can even write 3 pages on how I understand it, the question?
Yes, I haven't provided any page limit.
All right.
Because I don't want to say it must be 2 pages or must be 4 pages, because it depends on your time. Obviously, there should be more than enough time, but I also want you to realize that when the marker is reading your work, they need to see that you can get to the point as soon as possible and be persuasive and convincing, so that they give you your marks and they don't have to sit and read it and read and read and get tired and bored and forget what they've read. You know, try to be as precise and clear and to the point as possible.
Okay, thank you.
Okay, are there any more questions? Mahlat says hand is still... No? Nonhlanhla's finished as well? So
Yeah,
are we done?
I'm done, sorry.
Yes. Okay, perfect. I don't know if Mr. Mudau is still here. I don't know if he's got anything more to say. Probably not. I think he's also left us.
No, I'm still
Most,
around.
yeah. Okay. Look, I will. Oh, are you still here? Okay. Well, thank you, everyone. I know we didn't cover the public protector in as much detail, but next week I will do a full lecture revision. Mr. Mudau might join me. I'm not compelling him. So we will deal with everything we can next week. All right, are we all okay then?
Thank you, ma'am.
Thank you.
Yes,
Thank
we are fine. Thank you so much.
Enjoy
Thank
the
you. And thank you, Mr. Mudau.
Thank you.
Mr. Mudau.
Bye.
Thank you, ma'am.
Bye-bye.
Bye.
Bye.